Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about California Vehicle Code section 20001. That is felony hit and run. And the difference between felony hit and run and a regular hit and run usually comes down to a hit and run that actually caused injury to another person other than the driver who's being accused of committing the hit and run. And we see this a lot in situations that involve a DUI as well. So what starts off as maybe a misdemeanor DUI turns into a misdemeanor DUI with injury or a felony DUI with injury. And then when you flee the scene of the crime, and if someone was actually hurt and you had reasonable belief to know that that type of accident could have caused an injury and that you were in fact involved in an accident, then you could be and likely are going to be charged with VC 20001 felony hit and run. And we see that, like I said, a lot with DUIs. We see that sometimes without DUIs. Maybe the person was under the influence of something, left the scene, made that judgment call, and then they may very well be good for the felony hit and run. But again, just because you're charged with felony hit and run does not mean that's how the case is in fact going to resolve. Because what we see is there are certain factors that a district attorney will consider, certain factors a court will consider, such as what extent of injury did the other party involve in? What did they suffer? Was it, just some soft tissue, some bruising, or was it a real serious injury? And what was the reason that you gave, or what was the reason why you did in fact leave the scene? Were you under the influence yourself? Were you caught a short time later? Did you return to the scene? That's stuff that doesn't necessarily give you a defense, but could very well be a good mitigant that you realized you should never have left in the first place and came back. And also, what type of remorse you have, what you're doing to make sure that doesn't happen again. What, if any, out-of-pocket expenses the other party has suffered as a result of the accident, or certainly if you didn't stop and render aid or exchange identifying information. So all those things are important. And one thing also to consider is that if you're convicted of even a misdemeanor hit and run, that will also put 2 points on your driving record in California, which could be problematic if you have 4 points in a year, 6 points in 2 years, or 8 points in 3 years. DMV could try and say that you're what's known as a negligent operator and suspend your license for a period of time. And that's stuff that a lot of people don't think about when you're dealing with a DUI and a hit and run, especially a DUI and a felony hit and run causing injury, is that if you get convicted of both the DUI and the felony hit and run, or even the misdemeanor hit and run, you now have 4 points in a year on your driving record, and you're going to run into problems with DMV solely based on the number of points you have on your driving record. Something you want to be talking to your attorney about, something you may want to think twice about if your attorney's not already talking to you about if you have an active case involving hit and run, about what effect this could have, what effect a conviction could have on your driving record. So if you find yourself charged with a felony hit and run, even a misdemeanor hit and run, Vehicle Code section 2001, or 20002, reach out, give my firm a call, 619-295-3555.